Section 2 Continuation. Exemptions from licensing requirements. In many cases, those involved in any transaction involving the sale, lease, or exchange of a business opportunity must hold a real estate license. However, the following are exempt from this requirement. Individuals performing real estate activities on their own behalf, such as for sale by owner. Apartment resident managers or their employees. Corporate officers or general partners who receive no special compensation for corporation or partnership real estate activities. Persons holding a duly executed power of attorney from the real property's owner. Attorneys at law performing legal services for a client. Receivers, trustees in bankruptcy, or persons acting under court order. Trustees selling real property under a deed of trust. Persons or employees of banks, credit unions, insurance companies, loan institutions, pension trusts, savings and loan associations, or trust companies. Licensed securities brokers or dealers performing real estate activities in that capacity. Non-profit organizations. Cemetery authorities. Escrow agents. Residential mortgage lenders or servicers acting under that license. Individuals who, in a calendar year, make collections of 10 or fewer payments, or amounts of $40,000 or less on loans secured by real property. Real estate brokerage in CA. A real estate brokerage is the business under which real estate activities are performed. Real estate brokerages come in many shapes and sizes, but all must have at least one licensed real estate broker under whom all activities of the business are conducted. Common ownership structures for brokerages. Sole proprietor. Owned by a single person, can be licensed or unlicensed. May have employees or support staff. Must have at least one licensed broker under whom real estate activities are conducted. Partnership. Business is owned by two or more parties. At least one partner must be a licensed real estate broker. Each partner who conducts real estate activities must be a licensed real estate broker. Only one licensed partner represents the business as the broker of record. Corporation. An entity that may be owned by one or many parties. At least one officer must be a licensed real estate broker and act as the responsible designated broker officer for the corporation. Must obtain a corporate license by submitting a corporate license application and fee and a certificate of status provided by the Secretary of State. Doing business as DBA. If a real estate brokerage, no matter the type of ownership, will conduct business under a fictitious name, the following must occur. A fictitious business name, or DBA, statement is filed with the county clerk in the county where the principal place of business is located. The statement is valid for 5 years. A copy of the statement is submitted to California DRE, along with the appropriate application and fees. The name is not misleading and does not falsely advertise the services provided by the business. Brokerage offices. Every real estate brokerage must also have a principal office or place of business in California. This is the brokerage's main office. Some brokerages may also have additional offices where real estate activities are conducted. The licenses of the broker of record and any salespersons employed by the broker must be kept at this office and available for inspection. Address changes for the office must be completed by the next business day. Additional business locations must obtain a branch office license. This license must be available for inspection at the location. A licensee with at least 2 years of full-time real estate experience in the last 5 years may be designated as the manager of a branch office as long as their license is not restricted. Real estate license types in California. Broker. According to Section 10131 of the Real Estate Law, a person who, for a compensation or in expectation of a compensation, regardless of the form or time of payment, does or negotiates to do one or more activities requiring a real estate license. Activities. Selling or helping buyers purchase property. Negotiating leases, exchanges, options or business opportunities. Collecting rent. Helping someone apply to purchase state or federal land. Negotiating loans, collecting payments, or providing similar loan services for real property or a business opportunity. Selling real property sales contracts or promissory notes for real property or as a business opportunity. Additional responsibilities owed to employed licensees. Reasonable supervision of employed salespersons and brokers. Retention of employed salespersons' license certificates for duration of employment. Salesperson. According to Section 10132 of the Real Estate Law, natural person who, for a compensation or in expectation of a compensation, is employed by a licensed real estate broker to do one or more activities requiring a real estate license. Activities. Same activities as a broker, but must be employed by a licensed real estate broker, known as the broker of record at the time these activities are performed. Associate broker. Some licensees wish to hold a broker license, which may be more reflective of their level of experience, but don't want to shoulder all the responsibilities of a broker. An associate broker, also called a broker associate, is a person who holds a real estate broker license, but is employed by, and works under the supervision of, a broker of record. Essentially, an associate broker works as a salesperson, but holds a broker license. Activities requiring a California real estate license. Not every real estate activity requires licensure. You can sell your own home to your neighbor, for instance, without a license. Certain activities do require a license. There are two items to consider: payment and the act. An individual who is performing or negotiating to perform certain acts for others for compensation or with the expectation of being compensated must have a real estate license. These acts are found in Section 10131 of Real Estate Law. The activities include not only the doing of the following activities, but also offering to do them. So merely advertising yourself as someone who performs the following real estate services requires licensing. Selling or helping buyers purchase property. Negotiating leases, exchanges, options or business opportunities. Collecting rent. Helping someone apply to purchase state or federal land. Negotiating loans, collecting payment, or providing similar loan services for real property or a business opportunity. Selling real property sales contracts or promissory notes for real property or on a business opportunity.